matter
Ms.
with regard to that, what is that NTPS Act?
In fact, Ms. Bhuya had appeared on the last occasion. NDPS? No, not,
Paper book is ready.
not NDPS. Paper book is ready.
We can list it for hearing.
No, Lordship, we have received an instruction, Lordship, from our client, Lordship, that at the time of occurrence, Lordship, he was juvenile, Lordship. So we need to file a fresh IA, Lordship.
Okay.
So I may be allowed to withdraw, Lordship, the IA, Lordship.
This IA.
Lordship, only this IA, Lordship. And liberty may be granted to file a fresh, Lordship.
Okay, Jahan.
Lordship, even without the application, court can suo motu ask for a report whether it is juvenile or not. That can be done, but let him, he is filing.
You are Mr.
Ayu Chaudhary, Lordship.
He may be having
Mr.
some
Ayush
records.
Chaudhary, learned counsel for the applicant, prays for withdrawal of this present IA with liberty to file a fresh. MSS Jahan, learned addition PP, appears for the state of Assam. IA is accordingly dismissed on withdrawal with liberty as spread forth. And in the main criminal appeal,
Let the
Lordship,
juvenile
may
be
fix for
decided.
hearing, Lordship. Already paper book prepared, Lordship.
okay. Okay. In the criminal appeal, heard so and so for the appellant, also heard as Jahan, learned so and so for the state respondent. List, paper book is ready, list the matter for hearing in its usual course.
Not apply.
To hearing.
This matter was actually heard at length by the other bench, but not made part heard, I think.
It's not part of.
Not that Lordship can hear.
May I please, your Lordship, my lord? I can argue this case, no problem.
There's no issue.
My lord, your Lordship, the paper book is there, my lord. My lord, sum and substance of the case, my allegation is that one Betulus Ekka, my lord, he killed his brother, my lord. That is the allegation, that is the prosecution case, my lord. And only eyewitness is the wife of the deceased man. She later became hostile, and rest, my lord, or all are
Yes.
my lord, years later on they were told these are all extrajudicial conduct. My lord, that is the case, my lord. My lord, what I found, my lord, in this case, apparently initially I thought, my lord, the case is bad against me, my lord. But ultimately, while going through the evidence, my lord, I found that something is there in this case, my lord. I place your Lordship, my lord, that so much of discrepancies there, my lord, contradiction are there, my lord, in the evidence, my lord. It is very difficult to believe or somebody or someone will come to the conclusion that he has committed the offense, the crime. That is the case. My lord, let us start with the affair, my lord. Page 4 of the paper book, my lord.
Yes.
Yes. But the affair was lodged by the village headman, my lord, Ignis Means, my lord. My humble submission is that at 10 p.m. on 18/11/2015, Sri Betulus Ekka killed his brother Bosco Ekka by hacking him with an axe in course of a quarrel. The accused came to me and informed me about the incident, whereupon I handed him over to village defense party. On this 19 November 2015, I took the accused to the police station and handed him over to the police station. My lord. On the basis of this matter, subsequently charge sheet have been submitted, my lord, and prosecution examined as many as 7 witnesses, including IO and MO, my lord. My lord, let us, since there is only one alleged eyewitness, my lord, that is PW1, my lord, who has been declared hostile, my lord.
Page
8, my lord. Alexa, Srimati Alexa Ekka, my lord.
She is the wife.
She is the wife of the deceased man. Yes, ma'am. I know accused Betulus Ekta, he is my brother-in-law. That is, she is talking about the accused pilot. The deceased Bosco Ekka was my husband. The incident occurred about 3 months ago. On the day of incident at about 10 p.m., my husband came to my house in an inebriated condition. When he tried to enter into the room, he fell down. When the accused came out of my house for urination, he saw my husband and called me. My husband was alive at that time and he was breathing. I saw injuries on his chest, face. I do not know how my husband died, my lord. And at that moment, she was declared hostile, my lord. Now, cross-examined by the prosecution, my lord, that is what she stated before the police, my lord. The police inquired me about the incident. I have stated before the police, out of fear that my brother-in-law, that is accused Betulus Ekka, had killed my husband with an axe. I stated before the police that as my husband used to beat me, Betulus killed him. I have stated before the police that there was an altercation between my husband and the accused as well as myself, and the accused assaulted my husband with an axe. I have stated to the police, accused assaulted my husband inside our house. This is not a fact that I have stated before the police that I have seen assaulting my husband by my accused. It is not a fact that this is important. It is not a fact that I have stated before the police that I have seen assaulting my husband by the accused. I do not know who informed the police. Police came and seized the axe. I showed the axe to the police. Police prepared scissor list and took my thumb impression. I also put my thumb impression in the inquest report of my deceased husband. In my house, I lived along with my husband, 5 children, and brother-in-law. That is the accused. Presently, I am staying with my children. It is not a fact that I have stated falsely before this court. On the day of incident about 10 p.m., my husband came to my house in an inebriated condition. When he tried to enter into the room, he fell down. When the accused came out of my house for urination, he saw my husband and called me. My husband was alive at that time and he was breathing. I saw injuries on his chest, face, and do not know how my husband died. It is not a fact that what I have stated before the police was true. It is not a fact that I have given false evidence before this court to save my brother-in-law. Now, my lord, page 10, my lord, crossed by the defense. He was cross-examined by the defense, my lord. Accused is in jail since the date of his arrest for 3 months, 9 days. I have stated the truth before this court. On the day of incident, apart from my children, Rahul Ekka, son of my husband's sister, was also present in my house. This is very important. Later evidence also, it is there, my lord. These children were there present in the house, but they were not examined. Since last 5 years, my family resided with the accused. The relation between the accused and the deceased was good. On the day of incident, there was no altercation between the accused and my husband. When the accused saw my husband lying on the doorstep, he was in a badly drunken condition. My husband was lying on a piece of wooden plank. The accused picked up my husband, and who was in injured condition, and put him on a bed. At that time, my husband did not tell anything to me. He was alive at that point of time. Thereafter, the accused, along with Rahul Ekka, went to the house of one of our neighbor, Lazarus Horo. Not finding Lazarus in his house, he was staying at Gabriel Tapu's house. So the accused Rahul went to Gabriel's house, and both of them called to his house as the condition of the disease was not good. Thereafter, the accused Rahul, Gabriel Tapo, Lazarus, and Gambura, Ignis Minchi, came to our house. The accused was also all along present with my husband till the next morning. On the next day, accused Gambura and one another person went to Rangapara police station for giving information about the incident. Thereafter, the police arrested the accused. I do not know how my husband died. I have not seen the accused assaulting my husband. My husband used to drink every day. My husband had taken loan from different persons of our village. For this, on many occasions, there was altercation between moneylender and my husband. For this reason, people of our village did not like my husband. My eldest son is 16 years and Rahul is 12 years of age. Both of them are alive. They were not interrogated police. This is absolutely correct, my lord. In connection with the case, the houses of Gabriel Tapo and Lazarus Horo and Gambura means at a far distance from our house. When the accused went to call Gabriel and Lazarus, he took a half an hour to return back. I have not stated false evidence before this court. What I have stated before the police, I have stated out of fear. I have not seen any acts in the court today. My lord, now, how our statement, which part of our statement is supported by other evidence, that is to be seen, my lord, now. Because nobody was there. My lord. Only important witness, their children, my lord. They were present, my lord, but they were not interrogated or examined by the police. This is most important. My lord. And at the time of lodging of the affair, the wife was also not discussed, my lord. Next, PW2, my lord. PW2, he is very important also, Gabriel Topno. I know accused Betulus Ekka. Disease Bosco Ekka was elder brother of the accused. The occurrence took place in the month of last November. At about 10 p.m., I, along with Lazarus Soro, were sleeping in my house. At that time, Betulus came to my house and he was calling Lazarus to wake up. He addressed Lazarus as Dada. Myself and Lazarus woke up and Betulus informed us he killed his brother Bosco and he has kept the dead body in his house. I and Lazarus, along with Betulus, went to the house and I saw dead body of the Bosco was lying inside the house. The dead body was shown to us by Betulus. Thereafter, we three went to the house of Gambura Ignis Mint. The Gambura was sleeping at that time. Betulus woke him up. He was asking us as to why he had to come to his house at night. The Betulus told Gambura that he had killed his elder brother. The Gambura asked as to why he killed his elder brother. This time, we accompanied Gambura to the house of BDB Secretary Uday Soren. Next morning, police was informed by Gambura Ignis Minse. During investigation, I was brought to the court by police for giving a statement. I gave a statement. In that statement, I had given my thumb impression. I stated before the magistrate all the facts I have narrated today.
Who's this PW2?
PW2 is one of the person where my lord, after the said incident, my lord, they went to inform this man, my lord.
Neighbor,
Neighbor.
Neighbor, my lord.
tea garden neighbor.
Tea garden neighbor. They are all neighbor, more or less. Now, cross-examination part. I am a daily wage worker in a tea garden. I go to work early at 8 a.m. in the morning and come back at 4 p.m. On the day of occurrence, I had gone to my work as usual. The accused is not my relative. The deceased Bosco had his wife Alexa in his house and their 5 children. At the relevant point of time of occurrence, when I visited the house of accused, I also met his wife and 5 children. The house of the accused does not have electricity. My house is at a distance of about 100 meters from the house of the accused, my lord. On the date of his occurrence, I had gone to bed at 7 p.m. in a routine manner. When the accused visited my house on the day of occurrence, the accused was accompanied by his wife and deceased. Wife of the deceased. They were not accompanied by any other at the relevant point of time. Myself and Lazarus were sleeping in 2 different rooms in my house. When the accused came to my house, he did not enter the house. He was standing in my courtyard. Lazarus came out after 15 minutes. I belong to Adivasi community. We often have a liquor in our house as a customer practice. On the day of occurrence, I had consumed liquor. The accused hardly stayed in my house about 5 minutes and thereafter left out. As soon as I woke up from my sleep and immediately opened the door, I found Betulus standing in my doorstep. Lazarus is my brother-in-law. On that day, Lazarus had also consumed liquor along with me. At the relevant point of time, this is an important line, my lord, Betulus had talked with me only, not with Lazarus. And I on my own informed the Gambura as well, my lord. My lord, this is, my lord, contradicting these two, my lord. Well, I will come to later, my lord. He said his version is there, my lord. Betulus had told me only told me only, not with Lodrus, and I on my own had informed Gaumbura as well as Lodrus. It is not a fact that on the day of occurrence, the accused Betulas did not inform me that he had committed murder of his elder brother. It is not a fact that on the day of occurrence, actually the accused came to house to inform me about his elder brother had sustained injuries somewhere, and for that matter he was to take into hospital, and for that matter the accused approached us to help us to take the injured to the hospital. I am well aware of the fact that deceased Bosco regularly used to take liquor. But it is not a fact that on the day of occurrence I was in a state of sleep. For that matter, I actually did not hear what the accused actually told me. Next line, very important, my lord. On the day of occurrence, I was questioned by the police, but before gave the statement to police, there was a meeting in the village in connection with the occurrence, and in that meeting, I participated along with other villagers. Now, all these statements before the police were made after due discussion in a village meeting. What is to be told? It is from his version, it says not his view, because he has stated this is not a suggestion, my lord. On the day of occurrence, I was questioned by the police. Before I gave a statement to police, there was a meeting in the village in connection with the occurrence. And in that meeting, I also participated along with other villagers. The police station is situated 7 kilometers from our village. I do not know whether BDB secretary informed the police over phone. I did not inform the police. Next line important. I did not state before the police that accused had disclosed before the Gaumbura that he had killed his elder brother on the day of occurrence. This is very important line. I did not state before the police that the accused had disclosed before the Gaumbura that he had killed his elder brother on the day of occurrence. As a fellow villager, I personally know that the relationship between the accused and the deceased was good. I never heard any quarrel between the brother or about filing of cases against each other. The accused Betulas did not personally shown me the injuries of the deceased. It is not a fact that in order to grab the land of the accused, myself, Lodrus in collusion with Ignis Mince deposed false evidence against the accused. It is not a fact that on the day of occurrence, the accused and his wife, the deceased, had come together to my house. It is not a fact that I have deposed false evidence against the accused. Now, my lord, next, my lord, the VDB secretary, EW3, my lord. His name is Prem Uday Suren, my lord. I know the accused Betulas Ekka. And this is Bosco Ekka. The occurrence took place 18 November 2015 at about 10:30. Gabriel Betulas Lodrus Ignis Gaumbura had come to my house on the day of occurrence. I woke up from sleep. The Gaumbura Ignis Mensa told me that the accused had killed his brother. I asked Betulas as to how he killed his brother, and that he told me that he had killed his brother with an axe. I told them in that morning only necessary action would be taken on hearing that they went away from the house. Next morning, they again came to my house and I took them to the police station. I had written the ejar in the police station, and the Gaumbura Ignis Mince had put his signature in the ejar and filed the same. Exhibit 1 is the said ejar and Exhibit 1 is my signature. Now, my cross-examination by the defense man. At the point of time, at the time of occurrence, I had already served BDB secretary for about 6 years. The police station is about a distance of 7-8 kilometers away from our village. At that time of occurrence, I had telephone number of Rangapara PS since I was BDB secretary at that time. On the day of occurrence, I did not inform anything about the occurrence to the police by telephone or in writing. Now, he is telephone, my lord. He is the village defense secretary, my lord. He did not inform the police about the incident, my lord. On the day of occurrence, I did not visit the place of occurrence. He also did not visit the place. Myself, next and important, my lord, myself, Ignace Minche, Lordusoro, and Gabriel Topno are not the relative of the accused, nor we had seen the incident of this case. Although the wife of the deceased was alive on the day of occurrence, she did not file any ejar. Gambura Ignace Minche filed the ejar. Initially, one written ejar was filed by Gambura, but that was found to be incorrect, and therefore I was asked to write Exhibit 1, my lord. On the day of filing ejar, the police asked me about the incident, and therefore I did not give any statement before the police. My lord, next time, most important, my lord, I had not heard by my own that Betulas had informed the Gambura that he had killed his brother, elder brother. Now, these will nullify the other one. They said that he came and informed the Gambura regarding this incident, my lord. Here he said, my lord, I had not heard by my own that Betulas had informed the Gambura that he had killed his elder brother. Next line is also very important, my lord. I did not state before the police that I had asked the accused as to how he had killed his elder brother. He is contradicting his own statement from the chief, my lord. I did not state before the police that when I had asked the accused as to how he had killed his elder brother, he told me that he had killed his elder brother, which is X. Only Lodgerus, Ignace Minche, Gabriel Topno had told me about the incident. Other three persons had told him. My lord, is extrajudicial confession, my lord, practically. Only Lodgerus, Ignace Minche, Gabriel Topno had told me about the incident. When these three persons along with Betulas had visited my house, they were not accompanied by any children or wife of the deceased. This is very important, my lord, because other evidence said, my lord, his son came actually. I do not know how many children the deceased had, but I know that he had his wife in his house. I had never visited the house of the deceased because he resides in a separate locality. I knew the deceased Bosco C. Long. I also knew that he is a habitual drunkard. It is not a fact that Minche never informed me that the accused had informed that he had killed his brother. It is not a fact that I reduced false evidence against the accused. Next, my lord, Ignace Minche, this is the village headman, Gambura. His evidence is very important, my lord. He is PW4, my lord.
He is the informant.
Yes. He is the informant and he is the village headman. And everyone is saying that we inform him, he told us. So now let us see what he said. I know accused Betulas Ekka and deceased Bosco Ekka. The occurrence took place 18 November 2015. On the day I was at my house at about 10 p.m. I was sleeping in my house and Gabriel, Betulas and Lodgerus had come to my house on the day of occurrence. They were calling me as Nana, and I knocked and also knocked the door of my house. I woke up from the sleep and came out of the house. I asked them why they had visited my house in such a late hour. Betulas told me that he had killed his elder brother with an axe. Betulas told me that he is saying that the accused told him that he has killed his elder brother with an axe and the dead body was lying in his house. Thereafter, he came to my house with Gabriel and Lodgerus. I took three to the house of BDP secretary. Just I read his evidence, my lord. I woke him up and told him that Betulas had done something that he should be questioned by him. BDP secretary Premudaya Suren questioned Betulas, and he had told the BDP secretary that he had killed his elder brother, which is X, my lord. My lord, earlier PW said, my lord, this Suren, this BDP secretary, that nobody was told, my lord. But here he is saying, village admin, the Suren questioned Betulas and he told BDP secretary that he had killed his elder brother with an axe. It was late night, therefore we advised Betulas to go to his house and stay there till morning. We also told him that we will approach the police station next morning. Next morning, I went to the house of BDP secretary Premudaya Suren. Both of us went to police station. BDP secretary Premudaya Suren wrote ejar and I have put the signature. Exhibit 1 is the ejar. Exhibit 1-2 is my signature. Police came immediately and we also came along. Police brought out the dead body of the deceased inside the house. Police prepared the inquest report, Exhibit 2. Very important, later on will come, my lord, is the inquest report exhibit 2-1 is my signature. At the time of inquest report, I saw injury mark on the right side of the face of the deceased and on the chest. I saw injuries on the right side of the face of the deceased and on the chest. On being shown by the Betulas, police seized the X. On being shown by the Betulas, police seized the X. Exhibit 3 is the scissor list. Exhibit 3-1 is my signature. Material exhibit 1 is the seized X. Thereafter, on 20/11/2015, I was brought by the police to the court by giving evidence. I gave a statement. Exhibit 4 is the statement. Exhibit 4-1, 4-3 are my signature. This person also gave a confidential statement before the magistrate, my lord. I'll come to it later on, my lord. I spoke before the magistrate as I have spoken today before this court. Now, my lord, cross-examination part, my lord. I had been working as a Gambura for last 45 years. On the day of occurrence, I did not inform the occurrence to the police over telephone, my lord. This is one of the point also is required to be taken into consideration. He being a Gambura, somebody said that I killed somebody, my lord. But he did not bother to inform the police, my lord. Why? That's the question mark, my lord. On the day of occurrence, I did not visit the place of occurrence also. He being a village headman, he did not visit the place of occurrence also. He is not giving importance or is he involved in this case. There are other 4 houses between the house and that house of the accused, my lord. Only there were 4 houses between his house and the house of the accused, my lord. In the next morning on the day of occurrence, I also did not visit the place of occurrence. The next morning also he did not visit the place of occurrence. I visited the place of occurrence when the police had visited the said place, man. The deceased Bosco and his wife Alexa and also 5 children. Before filing FIR, I did not discuss Alexa or her children about how the occurrence took place, my lord. Well, he being a village headman, my lord. A person was there, my lord. His wife was there. Before lodging of the FIR, he did not bother to inquire what happened. Only there were 4 houses in between, my lord. How the occurrence took place. As a routine manner, I usually go to sleep at 8 p.m. In the evening, I had no electricity connection in my house. When Lodrus, Gabriel, and Bartolos visited my house, at that time I did not notice if they were accompanied by small children, Rahuleka. It was Lodrus, Gabriel, who initially informed me about the occurrence for the first time, my lord. It is the other 3 persons informed me about this, my lord. But in the chief, my lord, he said it is Betula Sekta informed me. In the chief, he said that Betulas told me that he had killed his elder brother with the next, my lord. But here he is saying it was Lodrus Gabriel who initially informed me about the occurrence for the first time, my lord. On the day of on that day when I had lodged the Ajar, at that time my statement was recorded by the police. Thereafter, police did not ask me about the incident. I cannot say on whose instruction the Ajar was written by BDP secretary. I was asked only to put signature in the Ajar. I did so, my lord. It is correct that the police recorded my statement. I did not say that the Betulas had told me that he had killed his elder brother with X. Now, with this statement, his chief will totally go, my lord. Nothing remains in his chief, my lord. It is correct. When the police recorded my statement, I did not say that Betulas had told me that he had killed his elder brother with X. I also did not state before the police that we had visited the house of BDP secretary with Prem Uday Singh. Very strange, my lord. Earlier, BDP secretary and other witness said that all three came to BDP secretary's house, my lord. Even this PW2 also said that the Gambura took us to BDP secretary. But here, what he said, my lord, I did not state before the police that we had visited the house of the BDP secretary Prem Uday Singh. I told him that Betulas had done something. He should be questioned by the BDP secretary Prem Uday Singh. Question Betulas, and he had told BDP secretary that he had killed his elder brother with an axe. BDP secretary Prem Uday Singh is a teacher by profession. BDP secretary Prem Uday Singh and myself had also gone to the police station to lodge the Ajar, and we were not accompanied by any other person. The occurrence took place on 18 and I gave my statement on 28th November. I did not inform anything to the villagers in connection with the incident. Myself, Lazarus Horo, and Gabriel Topper together came to the court to give our statement on the day of our statement was recorded. Next time, most important, my lord, I did not state before the police that I have given my statement under section 164 of the CRPC and in the court today in examination chief. At the time of inquest, I did not notice any cut injury, my lord. Earlier, my lord, in the chief, my lord, he said, I saw injury mark on his right side, my lord. But here he said, my lord, I did not notice any cut injury upon the person of the deceased. When the police seized material exhibit 11, I did not notice any blood stain in the said acts, my lord. I'll argue later on, my lord, that these were not sent for expert opinion, my lord. This is important regarding blood stain and all this thing, my lord. In the house of Betulus, cooking is done in an earthen wood fired stove. In most of the houses of our village, they have an axe for cutting wood for used in the stove. In material exhibit 1, type of axe is commonly found in our village. Material exhibit 1 does not contain any sign which would signify that it belongs to the household of Betulus. This question was also put, and it also came that such axe can be found, my lord, anywhere because these are commonly used there, my lord. I cannot read the contents of exhibit 3. I had put my signature only because the police asked me to put my signature therein. I cannot read and write Assamese language. I cannot say that what has been written in the exhibit 2. I had put my signature there only because the police asked me to put my signature. I belong to Adivasi community, and as a ritual, I usually drink regularly and thereafter go to bed, man. It is not a fact that in order to grab the land of the accused, myself, Lazarus Gabriel, had colluded together and filed false case against him. I knew accused Bosco very well. He was a habitual drunkard. No one had ever alleged any strained relation between the accused and the deceased. They always had very good relationship with each other. Now, PW5, my lord, Lazarus Horo, he is one of the person who visited, or prosecutor said, my lord, he was informed initially by the accused, my lord. I know accused Betulus Ekka, the disease and the disease Bosco Ekka. Both are brothers. The occurrence took place 18 November 2015. On that day, I was sleeping in the house of Gabriel at about 10 p.m. Betulus had come there. Betulus told us that he has killed his elder brother with an axe and dead body was lying in his house. We went to the house of Bosco and we saw he was lying dead inside the house. Gabriel myself took Betulus to the house of Gambura, Ignace Mince. He was sleeping at that time. Betulus called him as Nana. Before the Gambura, Betulus had confessed that he had killed his elder brother with an axe. This time again, we went to the house of Bosco along with Gambura, and Betulus showed us the axe by which he had killed his elder brother. Thereafter, we went to the house of BDP secretary. I do not know who had filed the HR before the police. When the police came to the place of occurrence, I was present there. Police brought the dead body of the deceased from inside the house. Police prepared the inquest of the dead body. Exhibit 2 is my signature. Police seized the axe after it was shown by his family member of the deceased. Now, leading to discovery also will not come here, my lord. The earlier said it was, he told, my lord, the accused showed the, my lord, axe, my lord. Here, my lord, it has come, my lord. The police seized the axe after it was shown by the family members of the deceased. My lord. Material exhibit 1 is the axe that was seized by the police, and exhibit 3-2 is my signature. Thereafter, 2011-2015, I, along with Gabriel, Gambura, and Ignace Mince were brought by the police to the court for giving a statement. I gave a statement. Material exhibit 5 is my statement. Exhibit 5-1, 5-2 are my signature. That is regarding confessional statement. I'll come to it later on, my lord. I spoke before the magistrate as I have spoken today before this court. My lord, cross-examination part. I am a cultivator by profession. On the day of occurrence, I was not sleeping in my house. On the day, on the next day of the occurrence, I gave my statement before the police. I did not state before the police that on the day of occurrence, Betulas visited my house and informed about the said occurrence. My lord, he contradicted his statement. His 161 statement, my lord, apparently, my lord. He has not been made hostile, my lord. Now, this part, how, my lord? My lord, I did not state before the police on the day of occurrence, Betulas visited and informed about the incident, my lord. That was not stated, must be not stated before the police.
Lazarus was not there at
Yes. Then later on came na, on the day of on that day, myself, Gabriel were sleeping on the same bed in the same house. On the next day of the incident, we also went to bed at 7 p.m. as a routine manner. When Betulas came to the house of Gabriel, he was accompanied by his nephew Rahul Ekka. My lord, now earlier said, my lord, earlier witnesses said, my lord, that they were not accompanied by any children, my lord. Or the Gambura also said he was not aware whether the children came, my lord. But here, my lord, is said when Betulas came to the house, he was accompanied by his nephew Rahul Ekka. Now, he was not interrogated, no statement was abstracted from him. After opening the door, because he was present in the house, if at all the incident took place at house, my lord. Apart from his mother, he was also present, my lord. He was 16 years old, my lord. After opening the door, I was the first person to talk to Betulas on the day of occurrence. Initially, the accused did not tell us that he had killed his brother with an axe. But when we asked as to how his brother died, then he told us that he had killed his brother with an axe. At first, Betulas told us his brother had died. At first, Betulas told us that his brother died. I belong to Adivasi community. As a ritual, we regularly take liquor before we go to sleep. On the day of occurrence, I took liquor along with Gabriel Mal. His cross-examination part is also very important, Mal. I knew Bosco since long, Mal. He did not do anything and roam around after taking liquor in a habitual, he is a habitual drunkard. People of the village did not like him because of his bad habit. I am aware that Betulas and Bosco had good relationship with each other. I never questioned the wife of the deceased and his children as to how the incident took place. In the house of Bosco, the other and the kitchen had an earthen wood fire stove. I did not notice any blast in a material exhibit 1, my lord, that is the X, my lord. He also did not notice any blast. And it was also not sent for chemical examination. The X like M material exhibit 1 are commonly available in the village, and it does not have any sign to show that it belongs to the house of Bosco, my lord. I cannot read and write, but I can somehow write my signature only. I cannot say what is written in exhibit 2. I had put my signature as a director by police. I also cannot say what is written in exhibit 3. I had put my signature as I was directed by the police. I do not remember where and when I put signature. Exhibit 2, 3. They were blank when I put my signature there. He said he put signature in the blank paper. Later it was prepared, madam. Next, madam. I did not, madam, very important line, next 2 line, madam. I did not state before the police. I did not state before the police that the second time I had visited the place of occurrence along with Gambura. On the night of occurrence, Betulas did not show us the X. That is, he is contradicting other man. On the night of occurrence, the Betulas did not show us the X, which was used by him at the time of committing offense. This is to be taken note of it, man. But earlier said, Gambura said, others said that the accused showed the X matter. Here, he said the accused did not show us. It is not a fact that on the night of occurrence, Betulas did not state before me that he had killed his elder brother with an axe. It is not a fact that I was present when Betulas arrived at the house of Gabriel. I had not heard anything said by the Betulas Gabriel. Now, next line, very important, my lord. Next few lines, my lord. When I gave my statement under section 164 of the CRPC, I was accompanied by Gabriel and Ignace Pince, and we had discussed within ourselves as what was to be stated before the policeman. These are all afterthought, my lord. They have mutually decided what is to be done, man. What statement is to be given, man. It is not a suggestion, my lord. It is directly they have stated, man. Now, next line, my lord. In my statement under section 164, I did not state that Betulas has killed Bosco with X. In his confessional statement, he did not say that Betulas had killed Bosco with X. It is not a fact that on the day of occurrence, Betulas had actually gone to the house of Gabriel seeking help to take his elder brother to the hospital. That is actually correct. This suggestion, this is the story, my lord. As he has sustained some injuries from somewhere, my lord. It is not a fact that in order to falsely implicate the accused, I have deposed false evidence against the accused, my lord. Now, these are the witnesses, my lord, on the basis of which, my lord, actually this conviction will be given. Now, how, my lord, such evidence, my lord, can be relied upon with conviction, my lord. But yes, he has killed, my lord. Everybody said, no, he said. No, he told me. He said, no, he did not tell him. He told him. It is like this, my lord. Now, when the cross-examination, they said, no, I did not state before the police or before the court that Betulas actually told me. This has come in the evidence, my lord. If we have to take one part, we have to reject the other part. Now, which part we will take, my lord? It cannot be on a piecemeal basis. Unless your lordship has come to the conclusion, yes, beyond reasonable doubt. Because this is not a civil case that preponderance of probabilities will prevail. No. Here, my lord, in a criminal case, my lord, we are to, my lord, convince beyond reasonable doubt. Well, yes, it is, he is the person. But it is very difficult. That how whether something else could have come out. But also, although police did not go in that way, my lord, but there is some element of doubt remain, my lord. All these witnesses, all these 5 witnesses contradicting each other, my lord. And more importantly, they are contradicting their own statement in the chief, my lord. Now, if we accept their chief, we have to reject their cross. If we have to reject their cross, we have to accept the chief, my lord. So which part will take, my lord? Now, let us see what the police say, my lord. This PWC 6, my lord. Basantu Kumar Bora, page 26, my lord. Ayo, my lord. On 19/11/2015, I was posted at Rangapara police station as a task officer, and on that day, Inspector Ziaur Rahman OC Rangapara PS received an FIR from Ignis Means of village Tapal Mill stating that on 18/11/2015 at about 10 p.m. one Bosco has killed his brother Betulas Ekka with an axe during quarrel between them and reported to the informant. After receipt of the information, the informant reported the matter to the BDP and handed over the accused to the police on 19/11/2015 in Rangapara police station. After receiving the FIR, OC Ziaur Rahman registered a case and endorsed the case to me for investigation. There is Exhibit 1 is the said FIR, Exhibit 1-3 is the signature of the OC Ziaur Rahman, which is known to me on communication. I have recorded the statement of the informant and interrogated the accused in the police station. On the same day, I visited the place of occurrence, that is the house of Bosco Ekka at Dapla Labil. I have also recorded the statement of witnesses at the police station. I have also prepared a sketch map of the place of occurrence. Exhibit 6 is the sketch map. Exhibit 6-1 is my signature. Thereafter, I have prepared the inquest report on the dead body Bosco Ekka in the presence of witnesses in the house of the deceased. Exhibit 2 is the inquest report. Exhibit 2-3 is my signature. I have also seized an axe, the weapon of assault, which is used by the accused at the time of incident, from the place of occurrence. Exhibit 3. is the seizure list. Exhibit 3 is my signature. Material exhibit 1 is the said X which was seized by exhibit 3. I have sent dead body for postmortem examination. Right, dead body challan exhibit 7 is the dead body challan exhibit 7 is my signature. On the same day, I have also arrested accused on 2011-2015, forwarded the accused to the honorable court. On the same day, I have sent witnesses, namely Gabriel Topno, Lazarus Horo, Ignis means to the court for recording their statement under section 164. CRPC. Accordingly, I have collected the statement under section 164 of the said witnesses during an investigation. I have also collected the postmortem report of the deceased on 30/11/2015 filed charge sheet against the accused Betla Sekka under section 302 of the IPC. Exhibit 8 is the charge sheet and exhibit 8 is my signature. The witness Alexa Ekka PW1 stated before me that out of fear, her brother-in-law, that is accused Betulas, has killed his husband with an axe. Said witness stated me that that there was an altercation between her husband and the accused as well as herself. She was also involved in the quarrel and the accused assaulted her husband with an axe. She also stated me that the accused assaulted her husband inside the house. She also stated me that she has been assaulting her husband by the accused. Exhibit 9 is the case diary. Exhibit 9 was the relevant statement of the witnesses of Alexa Ekka, and 9-2 is my signature under objection, my lord. Now, cross-examination. The distance between the place of occurrence and Rangapara police station is 12 kilometers. BDPs are commonly found in an area in and around the village of Rangapara police station. I have not been informed about the incident by the BDP personnel on the night of incident. The BDP secretary did not inform the police matter. On the next day of incident, because this thing cannot be taken lightly, my lord. This is a very serious thing, my lord. On the next day of incident, the informant Ignis means along with accused came to the police station and no other person were available along with them. I do not know. I do not know if BDP personnel have filed FIR prior to the incident FIR. That is exhibit 1. My lord, this line very important, my lord. On the next day of incident, informant Ignis means along with accused came to the police station and no other person were available with them, my lord. Actually, it is the BDP secretary who came and wrote the FIR. This was probably they are talking about the first FIR, but that first FIR is not on record, my lord. I do not know if BDP personnel have filed any FIR prior to the instant FIR, my lord. If it is the second FIR, then no case, there cannot be any case against me, my lord, because the first FIR was not brought on record, my lord. But the case has been proceeded on the basis of the second FIR. Case can be proceeded on the basis of second FIR, my lord, of the same incident, my lord. Because first FIR is there, because he is talking about the first FIR, my lord. Kindly see, my lord. On the next day, on the next day of the incident, informant Ignis means along with the accused came to the police station and no other person were available with them. I do not know if some BDP personnel filed any FIR prior to the incident. Prior to the incident, FIR dated 19/11/2015 at about I have visited the place of occurrence. I have not examined any children of the deceased Bosco. This is very important. This children were there, my lord. I have also not examined Rahul Ekka. This is also one of my case, my lord. Rahul Ekka, he was 16 years old, my lord. He was present at that. I have not examined Rahul Ekka, my lord. I have also not examined the neighboring witnesses. Very closest neighboring witnesses. Benjamin Horo, Joel Kaju, and John in connection with the case. At the time of seizure of the weapon of the assault, the said axe has no blood stain. It is the statement of the police, my lord. Other witnesses also said, my lord, there was no blood stain, my lord. I also have not found any stain mark of blood in the wearing apparel of the deceased Bosco, my lord. So our suggestion, my lord, that he has been probably assaulted by somebody else somewhere, my lord. Later on came in the house and died, my lord. That theory can be accepted, my lord, on the basis of this. Because had, my lord, the X part, either sharp part or the other part, he was struck, my lord, there would have been some stain, blood stain, either on the cloth or the body somewhere, but it's not there. It is a different aspect, my lord. The investigating agency, my lord, also on left that they did not send it for chemical examination. Acha. I have also not seized the clothes of the deceased. This is their left, my lord. The disease, the X was also not sent for chemical examination. It is there, not sent. It is their left, my lord. If there is any lapse or latches on the part of the prosecution, it is the benefit should come to the accused, my lord. At the time of inquest, I have not seen any cut injury on the disease, my lord. This is important. This is one of earlier in the cross-examination also it has come, my lord. So initially, the village headman showed that I saw injury mark on his body, all these things. These are all came to be false, my lord. Because the police himself saying, my lord, the investigating officer, my lord. I have sent all these three witnesses to the court for recording their statement under section 164 CRPC through requisition on 19/11/2015, my lord. In the statement of PW1, Alexa has not stated that at the time of incident, any quarrel took place and the disease between the deceased and the accused. Alexa Ekka is the wife of the deceased. She herself has not filed any AJAR in connection with the case. This is also important, my lord. The theory of that there is a quarrel is struck, my lord. Those were not brought. Those facts were not proved by the prosecution. It is their duty, my lord. It is not a fact that I had my own written. I by my own written the statement of Alexa and said, and she said, witnessed about assaulting her husband by the accused. It is not a fact that I had my own written the statement of Alexa that accused had killed her husband with an axe, because we have taken that down that she did not state those things. Man. It is not a fact that the statement under section 161 of the Alexa has been written by my own without being narrated by the witnesses. This ground we have taken that it is a manufactured statement. Man. Before taking the statement of the witness, Lorjus Horo, Ignis means and Gabriel Topo, their medical examination was not conducted by their not conducted as to their alcoholism. I have not visited the house of witness Gabriel Topo in connection with the incident. It is not a fact that seized material exhibit 1 do not belong to accused person. It is the informant came to the police station with an AJAR. I have no personal knowledge in whose dictation the affair was written. It is not a fact that I have not lawfully investigated the case and filed the charge sheet against the accused person. Now, my lord, PW7, that is the doctor, my lord. Injury part, we are not on that actually, but even then this is important in respect of this case, because I said no blood mark, no stain, even in the cloths or the ex, my lord, while because if he died on that way, my lord, that is on 19/11/2015, I was working as subdivision and medical health officer at Kanakolata Civil Hospital, Tezpur. On that day at about 3:30 p.m., I performed postmortem examination on the dead body, Bosco Ekka, male person, 40 years, son of the Sor Ekka of village so-and-so, Rangapara, in reference to Rangapara PS. Case number so-and-so, on being escorted and identified by Constable so-and-so. Now the injuries, my lord. External appearance, middle-aged dead body wearing blue jeans and pant, white t-shirt, average build height, muddy complexion and black and hair, abnormal movement of the jaw, fracture or mandible. Mandible means this part of the jaw part, my lord. There are abnormal movement, my lord. Contusion seen over the face, thorax. Thorax part, that is the chest part, my lord. In between abdomen, fracture of lower rib left side, nature of weapon, blunt object, my lord. Now that is also one part of argument, my lord. Now with the X, my lord, it cannot be the sharp part. Those were not actually proved by the prosecution, my lord. Well, by which part? Had he got intention to kill him, my lord, he would have killed him with the sharp one, sharp side. He would not have killed him with the blunt side, my lord. If at all, my lord, if at all, we can rely to that extent, my lord. This is very important, my lord. Spleen, rupture of spleen, peritoneum, clotted blood seen, mouth spleen, so and so. Other organ healthy, injuries are antibiotic in nature. Now cross-examination, my lord. No, my lord, opinion, my lord. In my opinion, the cause of death is hemorrhage and shock as the result of injuries sustained by the disease. The injuries are sufficient to cause death of a person, my lord. Postmortem so and so. The injuries sustained by the disease caused by blunt object. In column 5 of my postmortem report, it reveals that in the muscles bone of the joint, there is no deformity, fracture, or dislocation. Before conducting the postmortem report, I have gone through the inquest report and the injury found by the police done during the inquest report. I cannot remember whether these injuries found by the police on the disease as stated in the inquest report is in conformity with the injury mentioned in the postmortem report. This is very important, my lord. He is nobody's witness, my lord. He is a neutral person. Now, what is his view? His view is not certain, my lord. Very important, my lord. I cannot remember whether the injuries found by the police on the disease as stated in the inquest report. Inquest report is the first-hand report, my lord. Apparently, what can be seen, my lord, injury is in conformity with the injuries mentioned in the postmortem report. Postmortem report done by the expert doctor, my lord. Now, even here, the doctor also is not sure, my lord. Cannot say in conviction, my lord, in certainty. No, this is directly in conformity with this. We cannot say, my lord. These aspects also is very important in the context of this case, my lord. Because the case under section 302, my lord. He is the person, he is in jail, my lord. There is no direct evidence against him, my lord. It is not a fact that I have gone through the inquest report before conducting the postmortem report. I have not brought the original register of the postmortem report sustained, maintained in the hospital to ascertain whether the injury shown in exhibit exhibit 9 is true and correct with the original. There is also lapse, my lord, on the prosecution part, my lord. I have not brought the original register of the postmortem report maintained by the hospital to ascertain. Otherwise, this is not important, my lord. The medical part admitting, my lord. But him just saying, my lord, I have not brought the original register of the postmortem report maintained by the hospital to ascertain whether the injury shown in exhibit 9 is true and correct with the original. It is not a fact that exhibit 9 itself is the original one postmortem, so no certificate is required. Now, 313, I will, all these are denied, my lord. He does not know, my lord. Only question number 1, my lord, is important in connection of this case. Other than the general, my lord. Page 32 is the answer. Question is the, yes. Question PW1, Srimati, page 32, my lord. Question number 1. Srimati Alexa stated that your brother-in-law disease was her husband. The incident occurred about 3 months ago. On the day of incident, at about 10 p.m., her husband came to the house in inebriated condition. When he tried to enter the house, fell down. When he came out of your house for urination, he saw her husband and called her. Her husband was alive at that time and he was breathing. She saw injuries on the chest and face. She does not know how her husband died. His opinion, he said it is true. That is my case, my lord. That is other, my lord, general, all this question, he said, I do not know. I deny, I do not know, my lord. Now, my lord, the confessional statement would be important, my lord. Confessional statement, my lord, is important, my lord. I said, my lord, before giving confessional statement, they all had a village meeting, my lord. All had a discussion. There was a meeting of mind among them, and they have decided themselves what is to be stated. My lord, confessional statement starts at page 68, my lord. This is, of course, confessional statement of the witnesses, my lord. My lord, the Gambura, Ignis means, page 69 is his statement. Oh no. Around 10 p.m. on 18/11/2015, Battlefield Acta, Lazarus Horo, Gabriel Topno came to the courtyard of my house and called me uttering nana nana, grandfather. Then I woke up coming out of my house. I asked Betula as to why they had come so late at night. Then Batulu told me that he had killed his elder brother Bosco Ekka by hacking him with an axe. Thereafter, he sought advice. He sought advice from me with regard to that. Prior to coming to my house, Betula had met Lazarus Horo, Gabriel Topo, and confessed his guilt before them. They brought Batula to my house. Very important. They brought Batula. That means they also came to his house. After being aware of the incident, I took Batula to BDP Secretary Prem Uday Singh. Considering the matter to be a serious one, I wrote Ajar on the following day and took Batula to police station. Now, this is what they have said in the chief, my lord. In the chief. This has been cross-examined and duly demolished, this view, my lord. This statement they have made after due discussion, and subsequently, when they came to court, my lord, for cross-examination, my lord, they were duly cross-examination, and this view exactly the same thing what they have said in the chief, my lord. Now, 71. 71 is my lord Lazarus Hara. At around 10 p.m., 18/11/2015, Gabriel Topno and I were sleeping in Gabriel's house. At that time, Batalu came there and told us that he had killed his elder brother. Thereafter, we went to Batalu's house, and arriving there, we found Batalu's brother Bosco Ekka was lying there on the ground. Then Gabriel and I took Batalu to the house of village headman and informed later about the incident. Now he is contradicting his statement also. He said immediately he went to the house of the accused, my lord. In the chief and cross before the court, he did not whisper. He said when Batula came, they went to Batula Ekka's house. It is not there, my lord. They did not go to his house. They went to village headman's house. So he is contradicting his own statement here. Now, next, my lord. Yes, these two, I think. Statement is a confident. Yes, these two, my lord.
DW1 did not give.
No,
No.
164 only two.
Only two.
Lazarus and Dahula.
Yes. Now, my case, my lord.
Where's the inquest?
Yes. Inquest is there, man. Yes.
Page 63.
Yes, page 63. Page 63, madam. Rangapara PS concern. In connection with the case referred to, I, Basanta Kumar Bora, SI Police Station, arriving in the dwelling house of Ekka, and father of Betula Sekka, situated at so-and-so village on 19 November 2015. I, on being shown and identified by the undersigned witnesses, find the dead body of Bosco Ekka inside the house, and then hold the inquest on the dead body in the presence of witnesses to the following fact. This is found lying supine with the bed towards the south on the floor of the house. Hair is about 2 inches long, eyes are closed, blood oozing out of nose and both ears. Injury present below left ear, my lord. Mouth is open, nose bleeding, my lord. Deceased is clad in a sleeveless vest and pair of blue jeans trouser and pair of briefs. When the vest is lifted, it is seen that a grievous injury present on the chest, my lord. No injury seen on the abdomen, my lord. Waist, lower part of the body, both hands are lying parallel to the body, my lord. Hands are half twisted. Both legs are lying straight. Now, upon examination of the dead body by turning upside down, injury is seen on the back side of the head and back and waist. Though the witness have opined that Bosco died as a result of assault by Betula Sekka with axe on the chest, yet in order to ascertain the actual dead body is sent to Kanaklata Hospital, Tezpur for examination. As a result, same is awaited. My lord, that is That is the inquest report. Madam. On the inquest report also, he has been duly cross-examined, madam. Cross-examination part I have already read, madam. Now, in this case, my lord, first of all, my lord, extrajudicial confession. Otherwise, also extrajudicial confession is a weak piece of evidence, madam. Now, her hostile part. Now, there was only one witness. There were more than one witnesses. His wife, deceased wife is the eyewitness. And her children, my lord. She has been declared hostile. And her children were not examined. Not brought on record. This is the most important. This is the lapse. This is the fatal lapse, my lord. Person present, my lord. A 16-year-old boy was present in the room, my lord. He was not questioned. And before the lodging of the affair, the person who was present there, my lord, in the room at the time of incident, she was not discussed, my lord. Either Gambar or the BDB secretary, nobody said, my lord. Nobody went to the house and discussed with the wife, my lord. Actually, what happened, my lord? First-hand information is not there, my lord. My suggestion is my first-hand information, my lord. Now, my lord, the next question, my lord. The witnesses whose view has been declared hostile matter also can be taken into consideration. If the exact her story, her statement, or what is said in the 161 span or before the police matter, that has been corroborated by any other witness. So which witness is corroborated? All these witnesses are conflicting their own statement, my lord. No, nobody is clear here, man. Nobody can say, not a single witness can be relied upon for conviction of this person, man. Now, regarding this, my lord, non-sending of this, my lord, weapon, my lord, also fatal in a criminal case, my lord. I'll place one judgment, my lord. Although case is different, one subject fact is different, my lord. But just I'll place this judgment, my lord. Yeah. Just only one point I just like to place, my lord. Yes, ma'am. This is settled way back, my lord. The Supreme Court, 1975, Supreme Court 272. I'll place it, my lord. But just reading just one heading, my lord. Weapon and wounds. That is in respect of gunshot, my lord. That is the weapon which was used for the failure to examine the weapon of murder or fingerprint to connect the accused is extremely fatal to the prosecution case. That is in respect of this case. This is in respect of gunshot, my lord. But the principle applies same, my lord. I'm not saying it's a covered case, but the principle will apply, my lord. So what principle applies, my lord? These judgments are not overruled, my lord. These judgments are still alive, my lord. That is Datar Singh versus State of Punjab, my lord. 1975 4 SCC, my lord, 272. But here it is failure to examine the weapon of murder or fingerprint to connect the accused with the which is extremely fatal in a prosecution case. I'll just read this paragraph, my lord, small one, my lord.
You have copies of the judgment?
Yes. I'll place, my lord. I'll place.
Please, no.
Yes,
How many copies do you have?
Yes, 2 copy I have. I'll place one. Oh no, that is the rest judgment. I'll place in a set, my lord. Just for the sake of this point, my lord, I'm just showing. Oh, no problem.
Paragraph?
Yes, paragraph 23, my lord. Well, the main thing, my lord, the main part, my lord, I've handwritten one examination of the weapon used for murder, where the prosecution failed to examine the weapon of murder for gunshot. And it is extremely difficult, extremely fatal to the prosecution case. Statement Xerox করি আর বলে ছেড়ে দিতে control এখন। তিনটা তিনটা আমি বলেছি সাইড লাইন বলেছি উলাই দিব নোৱাৰিব তাকে আনিবই লাগিব দুটা দুটা আছে বন্ধুরা দেখবেন This is one latest judgment matter. This general one for extrajudicial confession matter. That is the 2002 live law matter, Supreme Court 529 matter. Here matter, the extrajudicial confession matter is a weak piece of evidence, and unless it inspires confidence or fully corroborated by some other evidence of is clinching in nature matter. Ordinarily, conviction for offense of murder should not be made only on the basis of extrajudicial confession. Here is a case only on the extrajudicial confession. This accused has been convicted matter. Extrajudicial confession made by the co-accused, this is different, even by co-accused also, could be admitted in evidence only as a corroborative piece of evidence. Had there been a co-accused also, that also it has got only corroborative value. But here no co-accused also in this case. Here it cannot be accepted. And so much discrepancies is there in this case, my lord. One said that it is he who is the first person to be informed. Other said, no, I am the first person to be informed. My paragraph number 12, my lord, it has been specifically discussed along with many judgments, my lord. It is a settled principle of criminal jurisprudence that extrajudicial confession is a weak piece of evidence. Wherever the court, upon due appreciation, entire prosecution evidence intends to base conviction on extrajudicial confession, it must ensure that the same inspires confidence and corroborated by other prosecution evidence. If, however, extrajudicial confession suffers from material discrepancies and inherent improbabilities, does not appear to be cogent as per the prosecution, but it is difficult for the court to base conviction on such confession. In such circumstances, the court would be fully justified in ruling such evidence out of consideration. Now, now it is up to your lordship, my lord. What I have submitted, my lord. Okay, my lord. On the basis of extrajudicial conviction, also conviction can be kept. But here, one person who said to be the eyewitness, the wife, my lord, he has been declared hostile. There is another person present, more person, like other children were also there. Another person was there, my lord, 16 years, his son. He was not questioned by the police, my lord, and he was there. He was the most important witness of the case, my lord. I would say he was the most important witness of the case. He was not examined by the police, my lord. Now, her part which has been declared hostile, my lord, was not corroborated by any other witness. The main witness, the informant, my lord, he is the Gambura. The Gambura said that everybody came to him. No. All witnesses said we all came to Gambura, and Gambura took us to the BDB secretary. Then we went to police station. The police again saying, Ayo said it is the Gambura along with the accused came only. No other person came. How, my lord? BDB secretary said it, he has written the AJR, my lord. And the Gambura has put the signature only. Even the discrepancy is there also, even in the lodging of the affair itself. And there are two affairs since, my lord, on record, my lord. That also has not been cleared by the prosecution, my lord. The prosecution seems to have relied, my lord, the PW, my lord, mainly relied probably the Gaambura, my lord, that is PW, that is PW4, my lord. And he is supported by PW, said to have supported by PW 2 and 3, my lord. But on record, my lord, they are all conflicting to each other, my lord. So these aspects, my lord, how, my lord, such thing, my lord, can be taken into consideration, because so far as even giving the statement before the police or also before the learned magistrate, my lord, they categorically stated that before giving all such statement, there was a village meeting, my lord. That means all these statements were, my lord, cryptic, my lord. They themselves decided that we will state like this. We'll make him that he has done it. That is my case, my lord. That he has done it because he died, my lord. So that man has died, and he is also a drunk person. They all drunk. He said that he has committed the offense. Because the wife and children, my lord, had, my lord, this man has actually killed his brother, my lord. His wife would not have become hostile, my lord. His son is there, my lord. They would not have cooperated with him, my lord. Well, this is very important, my lord. These aspects also is required to be taken into consideration. My father been killed by my uncle, my lord. My son is there, my wife is there, but they will cooperate with the person who has killed my father, my lord. Cannot be. It is very difficult to believe, my lord. Even till date also. It is very difficult to believe, my lord. And there is also nothing there. The prosecution did not bring anything regarding the relation of his this lady and his brother-in-law, or brother-in-law. There is nothing, absolutely pure, my lord. There is nothing, not a bad relation, my lord. He was staying there, my lord, at their house, my lord. So it is the story depicted or projected by us, my lord, probably could be correct, my lord. He was injured by somewhere else, my lord, somebody else, my lord. When he came, he was also drunk, my lord, so he is injured. So he came to their house, these witnesses' house, to take him to hospital, my lord. Probably that is the case. Probably. Because their version also cannot be believed, my lord, in toto, my lord. And that is my humble submission, my lord, that he has not been convicted, my lord, on the basis of my lord, on the basis of my decision arrived at was beyond any reasonable doubt, my lord. Because fraction of a doubt, my lord, with sufficient, my lord. And so far as this is a showing of this acts, my lord, by the accused, my lord, that has also been nullified, my lord. Because the other member has shown this the acts, my lord. It is not that the accused has also shown the acts.
Let us see that.
Yes, yes, it is not there, my lord. Because the IU itself said, my lord.
Produced by the wife.
Yeah.
It is produced by the wife.
Yes, yes, it is produced by the wife only. It is not that he is, no, it is admitted thing. So rest, my lord, subject to what my learned friend say, my lord.
That page 66, Caesar from Alexia.
Page 66, yes. Column 3, my lord, Caesar, RTI, Alexa. The other witness also said, my lord. Initially, their star witnesses said that it is I who showed my lord, showed them, my lord. But that has been nullified even by the IU also. And also by some of them also in their cross-examinations. My lord, I would just like to point out one paragraph again, my lord. Page 14, my lord.
Page,
Page 14. There is the last part of cross-examination of PW2, my lord. Page 14, my lord. Third paragraph, my lord. On the day of occurrence, I was questioned by the police. Before I gave a statement to the police, there was a meeting in the village in connection with the said occurrence. And in the said meeting, I also participated along with other villagers. And after next few lines, my lord, I did not state before the police that the accused had disclosed before the Gambura that he is killed his elder brother Devota. Now, my lord, one thing is sure, my lord. This person, they did not give their view or express their view just for the sake of stating the fact, my lord. Here they express their view after due discussion. After this discussion, meeting of mind is there, man. Then we will say like this. That is the discussion in the meeting, or why they will discuss. It is not that they immediately after got the information, they immediately intimated the police. No, they did not. Something is there, my lord. Something has been hatched against this person, this unfortunate. Probably. There is also probability. Their part is also probabilities, my part is also probability. Nobody is certain, my lord. Since nobody is certain, how I can be convicted, my lord, and sentenced for life, my lord. That is, I am submitting. Yes.
May please, Your Lordship. In fact, what I can see in this particular case is that there seems to be one only eyewitness in this case. That is the wife. She is the most natural witness who was there at the place of occurrence. But she turned hostile. But she turned hostile. Now it is no res integra because Lordship knows Supreme Court has time and again have decided that hostile witness will not go in toto. It can be relied on. Now what part can be relied on? That part which supports the prosecution case, her positive statement, which supports the prosecution case can always be relied on. I'll place a judgment on that. 2015, there is a judgment. Here what I see the wife, in her examination in chief, she said that he was lying on a wooden plank and my husband saw him outside the house. When he came to urinate and he went outside, he saw my husband and he called me. But in her cross-examination by the defense, she made few positive statements. Lordship can see at page number 9, which I can rely on. Page number 9. This is cross-examination by the prosecution after she was declared hostile. Police inquired me about the incident. I have stated before police out of fear that my brother-in-law, that is the accused Betulus, had killed my husband with an axe. I stated before police that as my husband used to beat me, Betulus killed him. I have stated before police that there was an altercation between my husband and the accused as well as myself, and the accused assaulted my husband with an axe. I have stated to police the accused assaulted my husband inside her house. This is a positive statement that she said that yes, I have stated to the police. So this part, prosecution, as I'm standing for the prosecution, I can rely on. And what the Supreme Court said in 2015 also, if the witness turns hostile and the witness gives positive statement, that I can rely on, coupled with few other witnesses, few other evidence which supports it. Then there is no bar in maintaining the conviction or giving the conviction. Now here, there are so many supporting evidence. Lordship will see, first, the accused, the deceased, the wife and the children, they stay together. They are together. They were there at the place of occurrence when the incident took place. Husband was there, her husband who was the deceased and the accused. So that is there at page 9 only. Lordship will go a few lines from the top in the 4th paragraph, which consists of only 2 lines. In my house, I lived with my husband, 5 children, brother-in-law, that is the accused. So if we see these circumstances, which corroborates, which supports her version, I find in my respectful submission that there are enough evidence to bring home the guilt. So they were staying together. Then PW2 had said, PW2 is Topno. There is no contradiction, as my learned friend had said. Topno said, in no unclear terms, he said that Lazarus was sleeping in my house. And accused came along with Rahul Ekka. He did not say Rahul Ekka, accused came. He said, I along with Lazarus were sleeping in the house. At that time, Betalus came and he was calling Lazarus to wake up. He addressed Lazarus as Dada. Myself and Lazarus woke up and Betalus informed us that he has killed his brother and has kept the dead body in the house. Topno had said this. This is again supported by Lazarus' statement. Lazarus said, yes, I was at Topno's house. Lordship will see, there are all corroborations. In fact, there are no contradictions. Little bit here and there, which does not go to the root of the case. That will not matter. He said, we were sleeping together and he came and he said he had killed his brother. The dead body was shown. And now, of course, there are some confusion, contradiction as to whether these people went back to the house of the accused, again went to the house of Gaunbura. Again with Gaunbura, they came back to the house, again went to the VDP secretary. Those few contradictions which does not go to the root will not matter. As far as the basic case is concerned, he came to Lazarus' house. Accused first went to Lazarus' house. He did not find him there. Then he went to Topno's house. Topno's house, Lazarus was there. There he confessed. There he said. Thereafter, we 3 went to the house of Gaunbura. And he said, after he informed us, we went back to the house of the accused and we saw the body there. After that, we 3 again went to the house of Gaunbura. And then Betalus woke up. Betalus woking up, he was asking as to why he had come to his house at this night. Then Betalus told that he has killed his elder brother. So today, Gaunbura also, according to Topno, Betalus confessed before the Gaunbura that he has killed him.
Let's see that part.
Yes, Gaunbura, Lordship will go to Gaunbura now. Gaunbura is at page. Gaunbura is PW4. Gaunbura, what he said. At 10 o'clock, the incident, by page number 18, Lordship will get it. 2 lines from the top. I was at my house. At 10 p.m., I was sleeping in my house. And Gabriel, Betalus, and Lazarus has come to my house. So all these 3 people got together because he informed they were together. Whether they went to house or not, that will not matter. These 3 had come to my house on the day of occurrence. They were calling me as Nana and knocked the door of my house. I woke up from sleep and came out of the house. I asked them why they had visited my house in such an hour. All these corroborates. In fact, all these statements corroborates. Topno also said the same question that the Gaunbura had asked. Why did you come at this hour? This, in fact, inspires confidence in the evidence of the witnesses. That is why I'm pointing out. Betalus told me that he had killed his elder brother with an axe and the dead body was lying in his house. Again to Gaunbura, he confessed. Thereafter, he came to my house with Gabriel and Lazarus. I took that 3 to the House of Defense, VDP secretary. I woke him up and Betalus woke him up, told him that Betalus has done something and he should be questioned. VDP secretary questioned Betalus and he told that VDP secretary that he had killed his elder brother with an axe. It was late at night. So we told him to go to house till morning and they will inform the police. Now Lordship, let us go to the VDP secretary. VDP secretary is PW3. Same statement, PW3, Prem Udait Suren. What he said at 10:30 p.m. because now incident occurred at 10 and they were coming here and there. At 10:30, they reached the VDP secretary's house. Gabriel, Topno, Betalus, Lazarus, Minse had come to my house on the day of occurrence. Now all the four goes. I woke up from sleep. The Gaubura Ignis Minse told me that the accused has killed his elder brother. Now Gaubura telling him or him telling him. Fact remains, it was told to the VDP secretary. All these four persons were there together. So they killed his elder brother. I asked Betalus as to how he had killed his elder brother, and he told me that he had killed his brother with an axe. He also tells, after he was questioned by the VDP secretary, I told them in the morning only necessary actions will be taken. And on hearing that, they went away from the house. And Lordship, let us see Lazarus' statement also. Lazarus is PW5. In fact, the accused went to Lazarus' house first, not finding him there. He went to Topner's house. Lazarus' evidence is at page, it is at page, Lazarus is PW5. Yes, page number 22. He said, I know Betalus Eka and all, both are brothers. The occurrence took place on so-and-so. On that day, I was sleeping in the house of Gabriel. At 10 p.m., Betalus came there. Betalus told us that he had killed his elder brother with an axe and dead body was lying. So Lazarus also says the same thing. He was sleeping in Topno's house. Betalus came and then he confessed. We went to the house of Boxo. He elaborates. He says that he comes back to the house of Bosco and we saw he was lying inside the house. Gabriel and myself took Betalus to the house of Gaumbura. He was sleeping at that time and Betalus called him. Before the Gaumbura, Betalus confessed that he had killed his brother with an axe. This time we again went to the house of Boxo. He came back with Gaumbura and showed us the axe to which he has killed his elder brother. Then we went to the house of VDP secretary. So as far as they're going together, reaching the house of Gaumbura, then going to the VDP secretary, these are all consistent in the statement of all the four witnesses. Now, whether they came back after informing Topno, after informing Gaumbura, that of course there is something, but that in my humble submission does not go to the root. The fact of the matter is that they went, they informed, and Betalus confessed. So these are kind of supporting evidence to the evidence of the wife, who had given a positive statement supporting the prosecution. And then Rahul Ekka, in fact, he was 16 years of age. No?
Yes, yes.
He was 16 years of age, it is said by the mother. No, he was 12 years. Rahul was 12 years of age. There are 5 children. If I have enough materials to show, non-examination of the children's will not matter. Here, the wife said in her cross-examination by the defense that accused along with Rahul Ekka went to the house of one Lazarus Horo. Wife had also given those statements in her cross-examination. Lordship will find that page 10. When she was cross-examined by defense, she said who went and what happened. Lordship will skip first 3 paragraphs, small paragraphs. Since last 5 years, my family resided with the accused. Relationship was good. On the day of incident, there was no altercation. When the accused saw my husband lying on the doorstep, he was in a badly drunken state. The husband was lying on a piece of wooden plank. The accused picked up my husband, who was in an injured state. At that time, my husband did not tell anything to me. He was alive. Thereafter, she did not say anything. Thereafter, she said, what she said is, accused along with Rahul Ekka went to the house of one neighbor, Lazarus Horo. Not finding Lazarus in his house, he was staying in Gabriel Topno's house. So the accused and Rahul went to Gabriel's house. Both of them called to his house as the condition of deceased was not good. Therefore, accused Rahul, Gabriel, Lajrush, Gaubura came to our house. These statements also corroborates who went where and how they came. The accused was all along present with my husband till the next morning. On the next morning, Gaubura and another person went to the police station for giving information about the incident. So she also said that the accused and Rahul Ekka went to the house of Lajrush Horo. Rahul is a 12-year-old boy. And another person had also said that Rahul had also come. That was in the statement of PW1 said Rahul. Rahul had also come. I found somewhere that Rahul had accompanied the accused. Put us later. I have got somewhere. Yes, page number 23, Lordship will get PW5 statements, Rahul, Lajrush Horo statement, because to the house of Lajrush Horo, Rahul and accused went. Page number 23, last but one paragraph. Lordship will find here on the third paragraph by cross-examination by defense. When Betalus came to the house of Gabriel, he was accompanied by his nephew Rahul Ekka. After opening the door, I was the first person to talk to. Now, whether he is the first person or Gabriel was the first one to hear will not matter because both of them were together in the house and Betalus went and confessed. And so he also said that Rahul was also with him. Thereafter, when they went back to the house, when they went to the house of the Gaubura, perhaps Rahul was not there.
Correct.
But initially, Rahul, perhaps yes, initially Rahul accompanied Betalus to the house of Lajrush Horo. So this also corroborates. So the story seems to be true in a way, because wife had said corroborated by these evidences. Thereafter, extrajudicial, there is no dispute with the fact that this is a weak piece of evidence. It will be taken only as a corroborative evidence, as a last resort rather. There should be other materials. So extrajudicial confession is there everywhere. This is also a circumstance which can be relied on to support the version of the wife.
What about the weapon?
Weapon, it is already, of course, 27 recovery is not there. Wife had shown to the police on 19-1 and it was recovered. There were no blood stains. It was not sent for FSL. And not proved whether that was the weapon used, but then an axe, which he was saying that I had killed with an axe. Axe was recovered from her house and wife had given. It can be only as a circumstance to support the prosecution case, because nothing was done further with the axe. But it was handed over by the wife and it was seized. Thereafter, Lordship will see 313 statement. Betalus Ekka had given an explanation in his last answer to the questions. 37, page number 37, Lordship will see. Would you like to say something? There he said, on that day at night, we have searched our brother Bosco. Searching brother Bosco actually is not evident from any other evidence, but could not find him. At last, we found him lying at the left side of a road in severe injured condition. He did not say about the wooden plank and all. Then I called Lajrush, but he was not there. Then I went to the house of Gabriel and Lajrush. Then to Gabara Akshay, this I don't know who he is, Gabara Akiash. Gabara Akiash.
No.
Gabara Akiash is not a witness. I am innocent. In the next morning, police called to me to the police station and arrested me. Now, this in my humble submission is not correct. Because first thing, they were now searching him. And he was not found on the road. He entered the house, according to the wife. And he was lying on an wooden plank. So this seems, in my humble submission, it's an incorrect statement that he has made. So incorrect statement again can be used by the prosecution to support the prosecution case. That will add as another circumstance is incorrect statement. So 313, the explanation that he has given is not correct. And what my learned friend had said, and 164 statement had all corroborated. 164 statement of Gaubura as well as Lajrush, page 68 and 71, that has corroborated again the statement of the wife. Because 164 can be used only for corroboration and contradiction. So Gaubura's statement given under 164 has corroborated his statement given before the trial court. He has stated the same things. So Gaubura also said, Batalu, same statements, even the circumstances, the happenings that had occurred before he confessed, that those are also same. He said, I woke up, Nana, they called me, they came, all three came. They woke me up. I asked Batalu why he had come so late at night. So the occurrences, the small happenings, those were also consistent. Why he had come at night, Batalu told me that he had killed his elder brother by hacking him with an axe. Thereafter, he sought advice from me with regard to that matter. Prior to coming to my house, Batalu met Lajrush, Horo, Gabriel, Topno and confessed his guilt. These things have all corroborated. Again, Lajrush's statement, Lordship has gone through, need not. I'll just read out Lajrush's statement. Batalu came there, told us that he has killed his elder brother. We went to Batalu's house. Arriving there, we found Batalu's brother was lying dead on the ground. Then Gabriel and I took Batalu to the house of village head and informed her later. So these statements are corroborated, in fact, to the 10% through their own statements before the trial court. Now, what my learned friend said, they had a discussion before going into it. Lordship knows in these village areas, whenever some occurrence takes place, they normally conduct a discussion amongst the village members. That will not affect the prosecution case. He did not say in so many words that we said what we had decided, we decided to say this. We had simply a discussion. We villagers met and we had a talk. But we will say this, we will say this. No, we will not say this. Those things are not there. This will not affect the prosecution case. This is a very minor contradiction that he had shown. Page number 24, that is what he had shown, that what was to be stated, that was decided. Let us see page number 24. Page number 24. He talks about 164 statement.
Discussion also better.
What he said, when I gave my statement under 164, I was accompanied by Gabriel and Minse, and we had discussed with ourselves as to what was to be stated before the police.
Yes.
This police is also wrong.
Yes.
In fact,
stated. What is to be
what was to be decided before the police while he was giving his statement under 164 to the magistrate? They are not talking about the magistrate.
Everything.
So whether this statement can at all be relied on, he talks about 164 statement and he said that what was to be stated before the police. So he is himself not clear what was he saying.
Yes.
This statement was already recorded after that 164.
That is
So
okay.
coupled with the evidence of the wife and these supportive evidences, I don't see that there is any contradiction going to the root of the case. The case is not proved. I don't find that. Extrajudicial is also can be a circumstance which supports. Lordship can see one judgment that I have just said, that I have mailed it 2012 4 SCC 722 on hostile witness.
Come again.
2012 4 SCC 722 paragraph 20. And doctor's evidence have also corroborated. That can also be a corroborative statement. Doctor had said that there are multiple injuries. There are injuries on the jaw was fractured, contusion on the face, thorax, abdomen, fracture of lower ribs, rupture of the spleen. And these, Lord, my learned friend said that the inquest report do not support. But inquest report does speak of these injuries. Lordship will just see once the inquest report of they already had seen. But the injuries part, what page number 63, last but one line. Even before that, blood is oozing out of the nose. Injury is present in the left ear. Nose is bleeding. Then Lordship will find when the vest is lifted, it is seen that a grievous injury is present on the chest. No injury is seen on the abdomen, waist, but later on he again says something. Or lower part of the body. Thereafter, Lordship will go. Now, upon examining the dead body by turning it upside down, injuries are seen on the back side of the head, back, and waist. So, injuries were there. It's not a case that they have not found anything. Yet to ascertain, yes. So, initially he said there were no injuries on the waist, but on the back side of the back waist, little bit which comes to the back side, there are injuries. So, injuries are there. Doctor's evidence is supported by inquest. Caesar list also Lordship had seen. It is given by the wife. So it can simply a circumstance that axe was recovered from the wife of the accused from his house. That will be the only circumstance, nothing more than that. So I would just sum up the positive statement of the wife along with corroborations from the evidence of all the four witnesses, 2, 3, 4, and 5.
Yes.
With all the four witnesses who were consistent in their statements, totally consistent with their statements, coupled with extrajudicial confessions. Then the 160 corroboration from the 164 statement. Seizure of the weapon. Incorrect statement under 313. Corroboration from the doctor and the inquest report. The case is proof beyond reasonable doubt. It's not a very long judgment. It's a long judgment, no? 49 paragraphs. Paragraph 20, I'm relying on this judgment. Only paragraph 20, but then it's a little long judgment. I think they have to take out. How about?
Confession to judgment to hostile.
Hostile.
That is there.
Hostile, that positive statement.
That is there. I also.
Lordship will see paragraph 20. I'll just read out, Justice Ete has not got. And there is the other copy, I think they have taken. Paragraph 20, I read out slowly. It is also not necessary. It is also not always necessary that wherever the witness turn hostile, the prosecution case must fail. Firstly, the part of the statement of such hostile witness that supports the case of the prosecution can always be taken into consideration. Secondly, where the sole witness is an eyewitness who can give a graphic account of the events which he had witnessed with some precision cogently, and if such a statement is corroborated by other evidence, documentary or otherwise, then such statement in the face of the hostile witness can still be a ground for holding the accused guilty of the crime that was committed. The court has to act with greater caution and accept such evidence with greater degree of care in order to ensure that justice alone is done. The evidence so considered should equivocally point towards the guilt of the accused. This is the paragraph that I wanted to place. So here her positive statement can always be taken into account, supported by other evidences. This is my humble submission.
My please, Your Worship, I've already raised my case. Only 3 words I just want to say. Only 3 words, my lord. Very important, my lord. Because my learned friend relied the evidence of the wife, my lord, who she has been declared hostile, my lord. Only 1 word, my lord. In the cross-examination, she said, police inquired me about the incident. I have stated before the police out of fear. This sentence is out of fear. He is admitting whether it is out of fear his brother-in-law killed or out of fear she is stating, that is also not clear, my lord. Page 9, my lord. Police inquired, I have stated before the police out of fear. This aspect also is required to be.
Out of fear, actually, I have related to the brother-in-law.
Now, that is, I might place it
of
like this
course,
also.
It can be both, it can be
Yes.
kind of interpreted in both ways.
Yes.
Next, I've stated before police out, because there's a comma here.
Out of fear. Out of fear, obviously, my lord, everybody, your lordship is well aware of it, my lord. Before the police, my lord, people, my lord, to save themselves, my lord, sometimes they also admit so many things, my lord. If thief is being beaten, my lord, sir, my papa, I have done it, my lord. Please save me, my lord. It is like this, my lord. Fear, because police, because people fear police, my lord.
But then there is a comma. What I'm saying, I've stated before police, so it ends. Out of fear that my brother-in-law accused Betalus has killed my husband with an axe. Because he was altercating, he was beating her. I stated before police that my husband used to beat me, Betalus killed him. So that out of fear perhaps will be linked with that, the subsequent sentence.
Yes, the probability only.
Because there is a
from both
comma
sides.
here.
And next word, my lord, only 2 lines, my lord. My lord, my learned friend said, my lord,
No, it original.
that all the witnesses, that is the Gambura, everybody went to Gambura and said that Betulas killed. Everybody went to Gambura and Gambura led to the police station. My lord, only 1 line I will read, my lord, page 20, my lord. It is correct that when police recorded my statement, I did not say that the Betulas had told me that he had killed his brother with axe. But he nullified his own statement in the chief. If chief goes, his 161 also goes. His confessional statement also goes. So that aspect. Only this by Ambedkar.
Page number 20.
The page 20, man, in the cross-examination of the Gambura,
Yes.
PW4. Man.
What contradiction?
That is the first line.
Acha,
It is
it's
correct.
When police recorded my statement, I did not state that Betalus has told me that he had killed his wife.
But in the chief and the police and the confessional, he said that Betulas told me that he has killed his wife. Man.
No,
And
what
that is-
his meaning is that he did not state to the police that Betalus had told me, but the other have told me, because he said initially,
Those things actually.
Acha, this Betalus told me, I asked him, the other 2 who were accompanying Betalus, he told him.
No,
I'll
no,
just
in
see,
the-
I'll just see the 161 statement.
No, I mean the chief, he himself said that Betulas told me that he is killing the chief. It is there, na? You see the chief. 161 will not come here actually. After the trial, 161 has no role actually. Page 11, my lord. In his chief, my lord. Page 18, my lord. In his chief, this man said, Gambura said, that Betulas has told me that he has killed his elder brother with an axe. And in the cross, he said, it is correct When police recorded my statement, I did not say that the Betula told me that he had not killed his brother with an axe. He is the informant. He is the main witness, my lord. He is demolishing his own case, my lord.
I'll just check up his 161 whether he has said Betalus.
No, but 161 will not come on here.
Yes, sometimes what happens, they say, but in the 161 statement, it is there. It is correct that when police record, I did not say, but I'll just see his statement.
Probably he said.
Uh-huh.
It is my view also.
What his statement is, Lordship perhaps will not understand as soon as I'll translate it. Tetia মদ খোৱাৰ VDP ঘৰৰ ওচৰ আছে একা
And everyone was drunk actually in a delicate condition.
শুন না অকমান চাই লওঁ ইমান বেয়া অৱস্থা দেই Assamese is so bad. বেটালুজ একাই কৈছে নেকি চাচোন এইটো তাৰিখে ৰাতি মই ঘৰত
আমাৰ 161 আছে নেকি?
ঘৰত থকা সময়তে
অ।
ৰাতি 10টামান বজাত মোৰ ঘৰৰ ওচৰত বেটালুজ এক্কা আহি কয় যে তেওঁ বোলে ট্ৰান্সলেট
yes তেওঁ বোলে
তেওঁৰ ককায়ে বস্কো নেকি
অ
বস্কো এক্কাৰ লগত কাজিয়া কৰি এখন কোঠাৰে মাৰি হত্যা কৰি
yes.
থৈ আহিছে
But in the 161, he said, while he was sleeping, Betalus Ekka came and said that after a fight, he had killed his brother with an axe. This statement is there before the police. But again, he said, I did not say. But
Yeah,
he said,
how his statement can be relied in the
yes,
context
of
in
course.
connection of this case, my lord.
in fact, because of this contradiction in one of the case, Justice Suman Shyam had sent it for taking additional evidence. That you ask the police officer, you ask this person again with these statements.
Can you check out that cross-examination of PW1?
PW1, I'll see what she had stated. Yes, cross-examination part in the. Yes, yes, this part whether she had stated, I'll see. Alexia Ekka, statement is short.
Cross-explanation.
He can around say read the DS. Alexia.
এজনী ন
Mm.
উপৰোক্তভাৱে তই ট্ৰান্সলেট কৰি যা
Mm, mm.
মোৰ নাম ঠিকনা সত্য মোৰ স্বামীৰ নাম বস্কো এক্কা তেওঁৰ নাম বেটালুজ এক্কা ককাই ভাই দুয়োজন একে ঘৰতে থাকে
They
মোৰ-
stay together.
they stay together.
Mm.
মোৰ স্বামীয়ে প্ৰায়ে মোৰ লগত হাই কাজিয়া কৰি থাকে
Husband fights with her every now and then.
স্বামীয়ে মোক সদায় লোকৰ লগত সন্দেহ কৰি আহ,
He suspects her with
Kajia
other
logai.
persons. Mm.
যোৱাকালি ইংৰাজী 18-11-15 তাৰিখে ৰাতি 9টামান বজাত
মদ পানী
9টামান
খায়নে?
মদ
No more. they
Are
don't.
you reading the examination in chief?
no
No, this
161
is her
statement of
161 because in her cross examination she said that I have stated to police to see I'm seeing this 161. That is how I'm placing this whether
Which
she has
part?
at
Which
all
part?
said.
which
A2.
part?
Police inquired me, I have stated before police out of fear.
out of
So
fear,
that
the fear
out of
part, no?
fear thing I just
Uh-uh.
wanted to see.
উম,
Hmm.
কৰিম। যোৱাকালি ইংৰাজী 18-11-15 তাৰিখে ৰাতি 9টামান বজাত মদ পানী খাই আহি মোৰ লগত মুখে মুখে তৰ্কাতৰ্কি কৰে বেছিকৈ তৰ্কাতৰ্কি হোৱাত মোৰ দেওৰ বেটালুজ এক্কাৰ খং উঠি সদায় কিয় হাল্লা কৰা বুলি ঘৰতে থকা এখন কোঠাৰে মাৰি মোৰ স্বামীৰ ঘৰৰ ভিতৰতে হত্যা কৰে মই মোৰ স্বামীৰ কোঠাৰে বেটালুজ এক্কাই মৰা স্বচক্ষে দেখিছো no fear
Mm.
factor তেতিয়া সময় 10টা মোৰ স্বামীক পৰা কোঠাৰখন চোতালত পৰি আছে বেটালুজ এক্কাই মোৰ স্বামীক হত্যা কৰি ওচৰৰ ইগনুছ
Mm.
লাজৰুছ আৰু গ্ৰেব্ৰিয়েলৰ তপক গৈ খবৰ দি মাতি আনে একিউজ ইনফৰ্ম
Accused informed.
অকে আজি ইংৰাজী 19-11-15 তাৰিখে ঘটনা তদন্ত কৰিবলৈ পুলিচ অহাত মই মৃতদেহটো আৰু ঘটনা ঘটোৱা কোঠাৰখন চিনাক্ত কৰি দেখুৱাই দিছো মৃতদেহটো পুলিচে চাই দেখি লিখি কৰিছে আৰু কোঠাৰখন মোৰ পৰা জব্দ কৰিছে মই পুলিচৰ কাগজত চহী কৰিছো That's
It
more clear.
doesn't, yes, it doesn't show that out of fear she had stated
Okay,
all.
let us see in the cross.
In the cross examination by the prosecution.
Yes.
Yes, she had said, police inquired me about the incident. Lordship wanted me to see this. Yes, I have stated before police out of fear that my brother-in-law, that is accused Betalus, had killed my husband with an axe.
Just check out if this is the proper translation.
No, this is the original.
This is.
This is the original. Is it,
No?
is it typed? Original copy is also typed.
I mean, the session judge has written it after translating it by herself.
It is typed in the trial court also.
It is in English. Same thing, it is in English.
Same.
Session
It
judge's
is the
translation.
original one.
So out of fear, what I'm saying by reading her 164, once statement, it doesn't seem that she had stated out of fear. And there is a comma here, I stated before police, out of fear because brother-in-law got. Original to comma. Yes, there is a comma here. So I don't, these statements, I don't think so. It was out of fear. What she said, out of fear, my brother-in-law had killed my husband. Because in her 161, she said that brother-in-law got annoyed. He was angry because of the attitude of the accused.
The sentence doesn't match actually. Out of fear, my brother-in-law killed him. How the sentence doesn't
Yes.
match actually.
Sometimes, of course.
Out of fear, it could be it should be I feared, but out of fear, he killed him. How the sentence doesn't match actually. Out of
So
fear,
in-
my
in
brother-in-law
case
killed
of-
my husband. Out of fear means what, my lord? It doesn't match actually.
In case Lordship, I'll have an alternative argument then. In case Lordship thinks that her statement, positive statement cannot be taken into account, then the entire case will rest on circumstantial evidence. So circumstances there are. Again, the things that I have said. One is that they were all staying together. It was at night, 10 p.m. Thereafter, there was an altercation and yes, they were staying together. It was at night. And then at night only, he came and confessed before all these people. All these witnesses are consistent in their statement that he had come and he had confessed. Thereafter, axe was recovered. Extrajudicial confessions are there. Then Rahul had also gone with the accused to Lajru's Hora's house. Those are corroborative statements, and these will become the circumstance. Incorrect statement under 313, corroboration by 164. Then these line of circumstances come. If your lordship wants, I can jot out the circumstance and give your lordship the small submissions. Because if lordship thinks that one cannot be believed, then these circumstances will prove the case, and the chain is complete in my humble submission.
You give your,
Circumstances, then I'll give.
if you want to give, you can give your submission.
Yes, yes. Well, the case is.
Heard, Mr.
Yes, yes, my lord. My name is A. Chaudhary.
S. Islam.
No, my lord, A. Chaudhary.
Oh, heard Mr. H. Also. For the appellant. Also heard MS S. Jahan, then in addition to PSR. When can you submit
Tomorrow, yeah, I'll just spell out the circumstances.
the matter again on? Okay, 31st.
Not. He's saying something. Okay. It's tomorrow.
Obliged.
Item 1 of production list.
Lordship, I have, yes, I have already submitted the written submission, madam. Probably other side is also submitted.
Okay, heard SD Purkayastal, Leonard Amicus Curie, also heard MSP Koyan, Leonard Public Addition BE. Assam. Hearing concluded. Adjustment reserved. See how one, no?
Lordship.
Item 5,
Two 2019 matter.
B Bhagavat.
5,
Mr. B Bhagavati comes otherwise. I have not Bhagavati. Hold on. Today he is not there, otherwise he comes. Your daughter was, she was set ablaze. She was poured kerosene and she died in the hospital.
Leonard Amicus Curious absent. MSS John Leonard Edition is present on behalf of the state. List again after 2 weeks.
No.
when?
Council was here in the morning, he asked me. Anuj Kumar Das.
Who was there?
Yes, Mr. Haloi was here in the morning.
Paper book is ready.
Paper book is ready. Not many evidence also. There are only 7 witnesses, 2 defense witness. It's a POXO.
Foxo matter.
Yes, POXO matter. Mother had sent her daughter to a shop, to the accused shop. That cannot be live stream actually. But then the advocate is not here.
Okay. None appears for the appellate.
Yeah, hello.
MS 2100. First on behalf of the state respondent. On behalf of the state. List again after 2 weeks. 2 weeks.
Okay. I think the council was waiting for this item number 7, but then thinking that this will carry on for long, perhaps he has left. Avlad.
11, no? 10, put number 10. That is again fixed for disposal today.
Oh,
So I was hoping that I'll be finishing this and I can go there.
in that case, I don't think we can wait for him. We'll have it on the same day then, April.
Yes, ma'am, that is better.
Okay, heard Mr. I. Chowdhury, Leonard Senior Counsel, assisted by Mr.
S. Vishwakarma.
S. Vishwakarma, Leonard Counsel for Petitioner.
Lordship, I am for the agriculture department. Lordship.
Also heard MS.
R.
R.
Boran.
Boran, Leonard Standing Counsel, Agriculture Department. On request made on behalf of P. Nayak,
P. Nayak, Lordship, for the finance department.
Leonard Standing Counsel, Finance Department. This is the matter again on. We said 27, correct?
27.
27.
27th April.
Obliged.
Completed.
C,
Right, please, your lordship. Lordship, today it was for the respondent to.
Who's the respondent?
Dibrugarh University, lordship. Standing counsel. Dibrugarh University. Rajesh Mohammed. Rajesh.
Dibrugarh University.
Rajesh. Dipali Khakon. Yes, calling.
Call out the next case.
Item 4,
He's coming.
He's coming.
Our multiplier is coming.
Call out the next case.
item 4,
May it please your lordship, on the last occasion, your lordship had directed the secretary to file the affidavit.
Yes, Lordship, here we will be filing the affidavit during the course of the day, Lordship, because of the budget session. The affidavit is on its way. We have not been able to file it as of now, my lords. But during the course of the day, we'll file it, my lords.
Okay.
They have not served me a copy, your
Yes,
lordship.
Lordship, we'll serve them a copy. Lordship, we don't have the hold of the affidavit right now because it went for signature, my lord.
Earlier occasion, you said you'll be filing on 8th of February.
Lordship, today my statement may be recorded. We'll be filing during the course. I'll serve a copy to my learned friend, my lord. Today itself.
Okay. Mr. Hurt, Mr. R. Sinha, learned counsel for the petitioner, Mr. P. Chalia, A. Chalia, learned standing counsel finance, health
Department, Lord.
department submits that he will be filing the affidavit as directed by this court on 8/2/2023 within the course of the day.
During the-
When shall we have it?
Tuesday, your lordship, that
Right,
day the
around-
matter can be disposed of.
It's the matter. See, next week, it's going to be very difficult.
Lordship,
You
BOP,
know the
after BOP.
problem.
Yes, your lordship.
Any date after BOP.
I think your lordship will be busy till 7th perhaps.
No, up to 14. Okay, let's try our luck on 11th.
Lordship.
This is the matter on 11th of April.
Your lordship may just record one day, one thing that on no further adjourn accommodation will be given to the
It is made clear
respondents.
that no further time shall be allowed to the health department to file the
Lordship.
affidavit as directed earlier.
3,
Deeply obliged, your lordship.
Where is Majumdar?
It's not yet come, my lord.
Will you sit some other day?
Yes, my lord.
You are Mr.
A Bhattacharya.
Hurt A. Bhattacharya, learned counsel. You're ready,
Uh,
Majumdar?
the- My submission in fact would be very brief, but from what had been earlier submitted, my lord. Recapitulation is required, then it will take time. Otherwise, my lord, on my
Okay.
point, I'm very clear.
What is it?
My lord, the recapitulation part, my lord, whatever they had submitted on the earlier round,
Hmm.
it's quite a long submission.
Hmm.
My lord, I would only proceed on the ground that the extent to which this honorable court may go into while appreciating a
Considering-
challenge to the disciplinary proceeding, my lord. I will limit my submissions to that.
Yes, sir.
In case there are
My Shivaji lacks in court number 4, madam. Let him start, madam. Actually, will come.
No. It's basically he'll be giving his answer. I want to have a recapitulation of the earlier.
because they had
Who's your senior?
You say I'm not, my lord. He's in lacks in court number 4, my lord.
Okay. Then we'll list it some other day
immediately after the vacation.
after vacation.
Yes, my lord, because now there'll be a time constraint every day.
The
There's a
date-
time constraint after vacation also, I don't know.
Maybe the last week of April may have some.
Whenever you're
On a hearing day you want.
on hearing, day, my
easier.
lord, it will be
I've already fixed 2 matters on 27th.
27, my lord.
Yes,
I've
ma'am.
already fixed.
This matter is part of matter. That's all.
Well, I've been on 25th then.
25th.
25th.
On the
My lord, the lordship's convenience, my lord, there's no problem. My
Missed the matter on 25th is the opening day after the vacation.
lordship may keep opening day, my lord, because everyone.
27th, first week of May.
The first week of May,
My lord.
4th May.
Fourth
May.
May, yes,
My
ma'am.
lord.
With respect.
First met by the parties.
My-
Just matter on 4th of May as part.
My lord.
Thursday.
Yes, yes.
Is it
It's a
okay?
hearing day, my lord. My lord. Lordship may keep it court out, my lord, otherwise.
Yeah, yeah.
my lord. Deeply obliged, my lord.
I'm obliged. Thank you. Very good. Well, it is. Okay. 10 চলি আছে না?